Hello, this is Matt on the Moon Lambo channel. What's going to drive more investors to jump into the crypto space? Well, arguably better tech is required. At least so says Ripple CEO Brad Garlinghouse. I want to share with you this headline from the Daily Hodl. This is what will drive more investors into the crypto markets, according to Ripple CEO Brad Garlinghouse. And there are a number of interesting things stated in here, including his take on what's happening with NFTs, non-fungible tokens. Because from his perspective, you'll see as we go through, it seems pretty clear that the layer one solutions for non-fungible tokens currently don't work. And I mean, hell, look at Ethereum. Gas fees much? I mean, come on. So that, while he's stating that, look at what's happening within the XRP ecosystem. There's an amendment being proposed right now, and hopefully it passes, as long as there's not any sort of tech reason to make anyone think that it wouldn't be safe. But the XLS20 amendment would provide functionality. It's a layer one of the XRP, the layer one in terms of technology stack on the XRP ledger. Now, that seems incredible because, as you well know, transactions on the XRP ledger are blazing fast, settled with finality in mere seconds at almost no energy usage and for fractions of a single penny. So might that be a game changer? Perhaps. Perhaps it will be. Look, if NFTs are going to be around, you need a better solution. And it looks like even if XRP wasn't on the front end in terms of the initial craze of NFTs, the XRP ledger might have some long-term viability there. So anyway, I'll share with you the Ripple CEO Brad Garlinghouse's thoughts. I also have a very short update regarding Jed McCaleb's selling of XRP. For those of you not in the know, he resumed his selling of XRP earlier this year, and he upped it within the last 6-7 days, whatever it's been. And he's going to be out soon. And then also there's this headline from you today. XRP lawsuit. Defense lawyer James K. Filan shares important incoming dates on updated schedule. So, per usual, plenty to talk about in this latest video. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. In we go. Ripple CEO Brad Garlinghouse is revealing what he thinks needs to happen to attract more entrepreneurs and investors to the crypto industry. In a new CNBC interview, Garlinghouse says that regulatory clarity and certainty are necessary to attract more participants into the crypto space. And here's a quote. "The industry lacks clarity and lacks certainty. The overwhelming majority of people working in the crypto industry, I think, are good actors that want to do right by regulators. But when the rules of the road aren't clear, it's very difficult to manage within that. And so for entrepreneurs and investors to participate in these markets, to invest in companies in this space, you want that clarity and certainty," end quote. Now, according to Garlinghouse, the U.S. is lagging behind other major developed and emerging economies under the G20 umbrella with regard to crypto regulations. Here's another quote from him. "Other countries that demonstrate how out of step the United States is really the G20. I mean, we talk about Switzerland here. We talk about Singapore. We talk about the UK, Japan. Even the United Arab Emirates is way ahead in providing that clarity and certainty that I think allows investors and entrepreneurs to build on these technologies," end quote. Yeah, and I always find it astonishing that there's only one country on the entire planet of 200-ish countries in existence. There's only one country on the planet that is asserting that XRP is a security, and even then, it's not the entirety of the United States government that is asserting this. It's one agency, the SEC, that is insisting this is a no-go regarding XRP. Just one agency. And my gosh, they could not be more incorrect in their assessment. I think that the time passed. History is going to bear that out. Anyway, looking at non-fungible tokens, this is the most interesting part from my perspective. Looking at NFTs, which have caused gas fees on the Ethereum blockchain to surge, the Ripple CEO says that better technologies are required. Think about this. XRP, one of the first cryptocurrencies ever to exist. It's existed now for almost 10 years. Almost 10 years. We're coming up on XRP's birthday, actually, in June. And it's just amazing to me that all these problems which we're seeing with these blockchains like Ethereum, and Ethereum, number 2 in terms of market cap, the most adopted smart contract platform on the entire planet, and the damn thing doesn't even work. It's basically a prototype, and maybe they solve this. Maybe they switch to proof of stake and things get better. I don't know for sure how this is going to pan out. It's not looking so hot right now. So if they can solve the scaling issue, fine. And I wish them the best. I'm just observing how things are this current state. But it is funny to think how the world of NFTs, where is it? Well, a big chunk of it's there, isn't it? And it's just interesting to me that XRP and the XRP ledger, it's perfect for this. It just needs a little bit of an adjustment here. Let this amendment pass, assuming it makes sense and it's not going to be any sort of technological risk, so on and so forth. It's just amazing to me that XRP ledger actually has a legitimate chance to dominate this portion of crypto in a meaningful way, in addition to all of its other use cases. So that's why I'm sitting here thinking, and we'll see. I don't know for sure if we're going to see that kind of adoption. I hope so. But if we actually do, what do you think that means for the long-term viability of XRP and the price of XRP in the decades to come? That's why I think people look back at this time and how cheap XRP and some of the other cryptos are and be like, my gosh, how amazing would it have been to have been living in that time and had that opportunity to make those purchases at such low prices. But here's what Brad Garlinghouse had to say. Here's a quote. As you go from first-generation technology to second generation, you get more specific use cases for specific types of solutions. I think we've even seen what's going on in the NFT market. The gas fees associated with NFTs are in some cases astronomical. Are the underlying layer 1 technologies able to support NFTs in the kind of first generation technology? I think we're finding probably not. We need to find better technologies that can support NFTs because I don't think NFTs are going away by any stretch, end quote. Exactly. And as I've been highlighting, and this is worth noting, it's not just about JPEGs. You can make funny jokes about NFTs just being about pictures on the internet, JPEGs and GIFs or whatever. But the truth is there's much more to it than that, and I don't think it's going to go away for that reason. It can help with royalties for content creators, whether you're a blogger or a musician, you name it. You can transfer ownership and make sure that when that happens, when sales are made, that royalties for each use for whatever it may be. That's game changing. That's going to change the way humans behave. This technology isn't going away. And so Brad Garlinghouse is rightfully acknowledging that the technology where this is being adopted is insufficient while pushing this type of adoption to the XRP ledger because it does make sense there and you won't have those types of hurdles. Food for thought, my friends. Now, I just have a real short update for this because I made a full video the other day, so I'm going to be super brief on this. But Jed McCaleb has. And of course, this is the co-founder of Ripple, co-creator of XRP and the XRP ledger. He's only got, out of his billions initially, of XRP, he's down to 223 million XRP. And for the last 6 days, he has upped. He's more than doubled what he's been selling from about 3.5 million XRP per day to a little over 8.6 million XRP per day for the last 6 days. So I just wanted to note, at the current pace, he's going to be out in about 26, 27 days. If that level holds, and there's no guarantee that it will, but I am looking forward to that day. The day that he is finally out of XRP, I can't wait to make a video highlighting that. And not because I think that it matters. I don't think that he's, in terms of him suppressing price, that's a bunch of garbage. It's a fraction of a percent in terms of total global volume each day, so he's not. But I'm tired of that narrative. That's the reason I'm looking forward to this. All right, now into this next piece. I want to share with you what attorney James Filan had to say. A couple days ago, he put out this update, and he had some interesting perspective regarding what's going on in the case. The part that I was most interested in actually was the attorney-client privilege stuff that he had to say. So I'm going to cover a portion of what he had to say. This is a document, and there were 4 screen grabs. I'm just going to cover the portion that I found to be the very most interesting. But it was an update on deadlines and what's going on in the SEC versus Ripple case. And so here you can go. Here, I'll just start this bullet point right here. The first topic, the deliberative process privilege and attorney-client privilege battle over the Hinman documents. And so you may recall that initially the SEC were claiming that, hey, you can't have these Hinman documents because they're privileged. It's secret, super duper top secret SEC information. And in January, we got word from the judge that no, you're going to hand these over because the speech was actually just Bill Hinman's personal opinion, so you can't claim privilege on these. And then they really didn't like that, so they filed a document requesting reconsideration. The judge reconsidered or took a look at the document requesting reconsideration and said, no, you still do have to hand these documents over. The SEC still really super duper didn't like that, so now they had a new claim. I can't believe they're fighting this hard. And it's attorney-client privilege. So now it's not just privilege in terms of deliberative process, now it's attorney-client privilege. So apparently Bill's coworkers who are attorneys he's their client because reason. That makes sense, right? That makes a ton of sense. And so they're doing everything they can to get out of handing over these documents. And I suspect the reason is that there's exculpatory evidence in here that would just destroy their case. And so Attorney Filan wrote the following. Regarding the deliberative process privilege battle, the SEC's motion for partial reconsideration was denied, and the motion for clarification was granted. Magistrate Judge Netburn ruled that the internal SEC Hinman documents were not protected by the deliberative process privilege, but then allowed the SEC to identify any of those documents that the SEC claimed were protected by the attorney-client privilege. Since then, the SEC has filed a letter explaining why it believes all the documents are protected by the attorney-client privilege. Now pause here. If the SEC really believed that every single email, every single judge, all of this is protected by attorney-client privilege, why didn't you start there? Why jump through all these hoops about deliberative process privilege when attorney-client privilege overrules all of that? It rides above that. Well, because they don't actually believe it. This is like their Hail Mary attempt. This is it. I don't think that they think this is going to work, but they sure as hell are fighting for it, aren't they? Attorney Filan continues. The Ripple defendants have objected, and briefing on that issue was completed on May 18th, 2022. So we are now waiting for a decision. If the SEC is ordered to produce any documents related to Hinman's speech, the SEC will file objections to Magistrate Judge Netburn's decision on both the deliberative process privilege issue and the attorney-client privilege issue with District Judge Torres. Now, the deadline for that is no later than 14 days after Magistrate Judge Netburn's decision. So I'll pause to note, I think that's going to happen, and you'll see Attorney Filan does seem to think that as well. I don't think Judge Netburn is going to like, oh, that's right, yeah, I didn't think about it like that. Yeah, that's attorney-client privilege after all. And then Ripple just doesn't get all of that information, and it can't be part of the. No, the odds of that seem incredibly low, do they not? I don't think that's going to happen here. So assuming it ends up being the case that Netburn's like, no, that's stupid. This is, she wouldn't word it like that, but this is not attorney-client privilege. Yeah, they're going to appeal to Judge Torres. And so anyway, Attorney Filan continues. He says, then the Ripple defendants have 14 days to respond to any objections the SEC files. That's 28 days before District Judge Torres even has to start thinking about the objections, which puts us, best case, well into June and possibly later. Folks, make yourselves cozy. We're going to be here a while. And then he says the following. If the SEC loses the privilege issues before District Judge Torres, there is a chance that the SEC would try to file an interlocutory appeal to the Second Circuit. They would have to get past significant procedural hurdles, such as the final judgment rule and the collateral order doctrine, to even be given permission to file an interlocutory appeal, and I don't think they would be successful. So what he's saying here is, if Judge Netburn says no, this is not attorney-client privilege, and then they appeal to Torres, and Judge Torres also says no, this is not attorney-client privilege, you have to hand this information over, this is what their next step might be. Saying, okay, you got to appeal to Second Circuit, that's what he said. So you have to appeal to a different court. Say, hey, these judges are wrong. Both of them are wrong. Second Circuit, come in here and help us. And if that happens, Attorney Filan does not think that the SEC would find success there, but he thinks there's a chance they may go for it anyway. And then he continues. In fact, the Supreme Court has ruled that a party may not bring an interlocutory appeal of an order denying a claim of attorney-client privilege. So, folks, might not even be able to bring it in the first place. And he continues, that said, I do expect the SEC to try to get those issues before the Second Circuit, probably through a petition for a writ of mandamus, and that will take some time to decide. Although the standard for granting such a petition is high, the Second Circuit has issued at least one decision in which it granted a petition in a discovery-related case involving the law enforcement privilege. As I mentioned in a tweet on April 20th, 2022, I think a decision on those issues would be made while the summary judgment motions are pending, which is why I believe the Ripple defendants have stated they are prepared to go forward on summary judgment before that issue is decided. Yeah, exactly. So they're ready to have the case wrap up. Let's go to summary judgment, even though this isn't settled, because Ripple's attorneys think it will be settled by then and will be a non-issue, so let's get the rest of it rolling. That's pretty much it. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.